Welcome, everybody. See what I mean? They're loud.
It takes all the fun out of it.
They are loud. Thank you, everybody, for coming today. This is terrific. Looks like we're back in the full swing of things again, right? We are starting to work on bills for next year. Everybody's back from vacation pretty much, so it's time to get down and solve a lot of our problems. Is there a way to lower it? You just want to gavel in. That's all you wanted. Tell me to lower it. So first of all, let's do introduction of our committee members, and we'll do some opening statements. Lupe, do you want to start?
Senator Contreras, District 19. End of my fourth year here at the Senate, starting off my fifth. For those like my guys to my left here are kind of mad because we don't have a general election, so that's okay. We'll see you back here in January. But yeah, District 19 encompasses Tolleson, Avondale, West Phoenix, and I'm a lifelong resident of not only my district, Arizona, and my little circle, my little town. So it's nice to be back here.
Great. Thanks, Lupe. Speaker Pro Tem Shope.
TJ Shope, Legislative District 8. I reside in Coolidge. And District 8 goes basically from Casa Grande on the west to Globe, Miami, and Oracle Samuel on the east. So pretty wide area, but looking forward to an enjoyable time. If I had known Representative Espinoza and Senator Contreras were on the committee, I may have thought twice. But this should be a fun time nonetheless, and I do enjoy their company regardless of what they say. And of course, Senator Fan as well. I mean, the illustrious Senator Fan.
Yeah, right. Thank you, Madam Chair, Co-Chair. Representative Diego Espinosa, Legislative District 19. I have the fortunate opportunity to serve with Senator Contreras in representing our district that we have grown up in and seen it flourish. And looking forward to working with all of you all. Also like to congratulate Mr. Shope here on a recent engagement.
Yes.
So that's awesome, and it's a pleasure to be serving on this committee and looking forward to working through these issues and making some opportunities and improving whatever it is that we need to do here, or maybe potential opportunities that we may see in these study committee, and pass them forward and have a successful outcome. So with that, turn it back over, ma'am.
Thank you very much. All right, and we do have two other members that at the last minute could not attend. That would be Senator Rick Gray, who was pulled away at another meeting, and Representative Jill Norgard, who had to go to L.A. this morning. So we will bring them back up to speed on everything. I am Senator Fan. I was the sponsor of this bill last year, 1271. It's a big bill. It's a huge bill. It's one of those bills that is touchy, can be controversial because a lot of people are involved and a lot of issues are involved. I'm bringing some of this up for the benefit of our House members on the committee because the bill was ready to go out of the Senate. We had the votes to get it off the floor of the Senate and send it over to the House, but because there was the politics involved and what I call the rhetoric and all the issues that were going on at the last minute, I had decided to go ahead and turn this into a study committee to give us more of an opportunity to be able to sit down and talk this through rather than battling it out amongst our members. So for our House members, this was something that was dearly fought, and but we're going to move it forward, but we're just going to do it a little bit easier here. I'm very encouraged, and you will hear from some of the speakers here today, is that we are already starting. I am pleased to say that these both sides, all sides of the issue so far, we are sitting down, talking out, and trying to figure out how best to do this. One of my suggestions, and I believe this is what they're starting to work on, is try and find common ground between the sides, first of all, so that we can figure out what we agree on, solve those issues, and then we can tackle maybe the more difficult things that we aren't so easily agreeable on. One of those big issues that you will hear about is frivolous lawsuits. As you know, we have sometimes attorneys from California that like to come over and trying to make a little extra money for themselves. They will create issues that maybe are or should never be there. So we're going to figure out how we can solve that problem so that our contractors, subcontractors, developers, that we're all working together as a team on that one. Obviously, we also want to make sure that we protect the homeowners, and if there's a legitimate complaint, we take care of them as quickly and expeditiously as possible. And part of that will be working closer with the Register of Contractors as part of this whole thing. And then once we get the second piece that you will hear about is helping to bring everybody to the table up front and still waiting till the end. Sometimes when you wait till the end, things have gotten so far that it's hard to fix problems. So we want to figure out how do we fix those problems up front. And lastly is that last piece that is the most contentious piece is proportional liability. If there is a problem and if someone is at fault, how do we actually determine who's at fault to what degree, and what's the best way to resolve it that's fair for all concerned? I sound like I'm in my Rotary meeting right now. For those of you who know the Rotary pledge. So that is kind of it in a nutshell as far as where we've been and where we think we're going to go. And with that, I will turn it over to Grant Hanna, who is going to start with the background of what the law is and what. Then we're going to figure out how to fix it.
Thank you. Good morning, Madam Chair, Mr. Chair, and members. For the record, Grant Hanna. I'm the research analyst here at the Senate for the Commerce and Public Safety Committee. Senate Bill 1271, as Senator Fan mentioned, established this committee to research and make recommendations for the apportionment of liability in the construction industry. I have prepared a short presentation to review the committee's charge prior to your discussions and presentations, as well as go over just a few of the basic concepts that will be emerging as this discussion progresses. You should have copies of the presentation up front, and I also have copies at the front of the room if anybody here would like one. So to review the committee charge as established by Senate Bill 1271, broadly, you're going to research and make recommendations for apportionment of liability in construction contracts, and then you have 6 specific directives. The first is the use of an indemnity provision in construction contracts, and we're going to cover what that means. The second is the allocation of liability based on degrees of fault. Third is the assignment of financial responsibility to negligent parties. 4 is the opportunity to address and remedy alleged construction defects prior to litigation. 5th is the frequency of construction defect litigation. And finally, the last directive is the affordability of insurance costs associated with construction claims. So to go over a few basic concepts that are currently in state law, the first directive has to do with the use of an indemnity provision in construction contracts. An indemnity clause, as used in construction contracts, requires a performing party, such as a subcontractor, to hold the contracting party, such as a general contractor, harmless for any liability or harm arising out of performance of the contract. In contracts for public works, the legislature in 1996 and effective 1998 prohibited use of contract clauses that require a subcontractor to indemnify a general contractor against liability caused by the general contractor's own negligence. However, a general contractor may still indemnify itself against harm caused by the negligence, recklessness, or intentional wrongful conduct of the subcontractor. The fourth and fifth directives of the committee specifically mention construction defects. And as pertaining to residential construction, really all 6 directives relate to construction defect litigation, but briefly wanted to cover what a construction defect actually is. Resolution of construction defect disputes are covered under Arizona's Purchaser Dwelling Act. For context, I've included in your materials the definition of a construction defect. In statute, construction defect is a material deficiency caused by violation of construction codes, use of defective materials, or a failure to adhere to general workmanship standards. The statute also contains a definition for a material deficiency, and this is a deficiency that actually, at the time of filing or in the foreseeable future, if there's not a repair or replacement done, will impair the structural integrity, the functionality, or the appearance of the dwelling. So statute under the Purchaser Dwelling Act contains generally a three-step process before litigation that involves purchaser notice, seller inspection, and then the seller's response. The homeowner's notice to the seller must specify in reasonable detail the basis for the dwelling action. Notably, the home builder's insurance at this time on receipt of this notice will treat or must treat the notice as a claim under the insurance policy of the home builder in this case. Following notice, the homeowner makes the dwelling available to the home builder to inspect the nature of alleged defects. And at that time, the home builder or seller can judge the nature of any repairs or replacements. And then the seller's response will include or may include a notice of intent to repair or replace any alleged defects. In 2015, the legislature established a seller's right to repair or replace prior to any litigation. Statute dictates the process and parties' rights prior to litigation. That includes any applicable timeframes and also a homeowner's right to request that a different subcontractor than the one that originally performed the construction come in and do any repairs or replacements. So returning to the committee charge, hopefully that explanation of indemnity clause and construction defect serves as a foundation, and pun intended there, for your future discussions. The law, Senate Bill 1271, that established this committee requires your research and recommendations to be submitted by December 15th of this year, and that will go to the governor, to the president of the Senate, and the Speaker of the House. And with that, I'm happy to answer any questions.
Thank you. Members, do you have any questions for Grant? Not this time? Okay, we can bring him back up. I just want to make one other notice is Representative Shope is not the only one that got engaged. Somebody else got engaged a couple of weeks ago himself. So congratulations, Grant.
Thank you very much. She actually was.
I did.
I'll say hi, Maggie.
Thank you, Grant. Appreciate that. Okay, members, here's what we are going to do next. We are going to bring up a couple of the principals involved with this so that they can help guide us and explain where they see the issues at. I have asked them both to limit it between 5 and 10 minutes because we could go on for hours. This is that intricate. I thought you might like that. Some people have to get back to work. So we're going to try and limit this between 5 and 10 minutes so that they can basically get their thoughts, ideas, concerns, suggestions out in that period of time, and then we'll bring up the next. So the first coming up is from the Habaka developer side of it is Kevin O'Malley with Gallagher and Kennedy. Good morning, Kevin. How are you?
Very, very well. Thank you very much. Chairman Fan, Chairman Shope, and members of the committee, my name is Kevin O'Malley, and I represent the Home Builders Association. And I can jump right into some comments because Grant did a very good job of summarizing where we are today in terms of the law. And what I hope to be able to do today is to answer any questions you might have, to provide a little perspective. I've been involved in this since the legislature first passed a bill in 2002, so 18 years or so we've been working on this, making various amendments and changes and so forth. So please ask questions if you have any. I'm not here today to offer any specific proposal for legislation going forward, but to hopefully provide a little bit of context for the issues that were the subject of our study. Let me go back then to the early 2000 timeframe, and I got a call from the Home Builders Association saying, you know, we've got a new animal out there. We're getting these mass lawsuits with hundreds of homeowners. We don't have any notice before the lawsuit gets filed, and we are trying to figure out why that's happening. And we go out to some of the homeowners and find out that they're getting letters and getting solicited to join a lawsuit. This is entirely different than we had experienced in the past. In the past, we all recognize no home is ever perfect. There are going to be problems. That's why there's warranty departments and service departments and so forth. But if we had a problem, what would occur is a homeowner would call and they'd say, I've got this problem. It's a plumbing problem. So we would have a contract with our trade partner, which would be the plumber, and say, under that contract, you have to indemnify us. You have to take care of this problem. You have to stand behind your work. Plumber would say, of course I do. And they would come out, they'd fix the problem and so forth. If for some reason there was a dispute about that, then there might be a lawsuit. Not very often, but there would be occasional lawsuit. Under the indemnity provision, that plumber, recognizing this is my problem, would go ahead and defend the lawsuit. We didn't have fights between the trade contractors and the general contractors about how to allocate proportional responsibility, any of that, because we were getting the problem solved. So we look into this problem and we find out it kind of emanates from California. As Senator Fan mentioned, there were these California law firms, started this process in California, came to Arizona, set up shop, and started recruiting homeowners by the hundreds in various communities around our state. So we got in an airplane, flew over to San Diego and said, what's going on? They said, well, here's how these CD lawsuits work. They go out, they recruit people, they have a group of forensic engineers that go out and come up with a list of defects. It's not one or two, it's dozens, sometimes 50, or I tried a case with 64 separate defects, alleged defects. And what happens then? Well, under the law, the homeowner, if you have a plumbing problem, you can't sue your plumber. You have to sue the home builder. And then the home builder has to go bring a plumber into the case by a third-party complaint. So we get these allegations of 50 problems, and that goes across 12 subcontractors. So the 12 subcontractors are brought into the case. Then what happens? They all have insurance companies. So the insurance companies now take over, right? They start doing their investigation. You're into a massive lawsuit with dozens of parties and 50 alleged defects. So then what happens? They do their investigation, and the insurance companies are in the insurance business. They're not in the construction business. So what do? They eventually realize, it's going to cost me $100,000, $200,000 to try this case. The plaintiff says, I'll take $50,000 now to settle it. Okay, we'll settle the case for $50,000 because that makes good sense to the insurance company. Then what happens? They turn around and send a letter to the subcontractor saying, we just settled your case. You didn't get a chance to defend your work. You didn't get a chance to have your day in court. And by the way, you have a deductible of $5,000 or $10,000. Send us a check. And then the next one comes, and the next one comes. And so the trade contractors are upset, as they should be. And they're writing checks and not being able to defend their work. Is that fair? Is that reasonable? No, it's not. So I have complete sympathy and empathy for where the trade contractors find themselves. It's not a fair process. So SB 1271 was introduced last year to say we got to fix the problem of these trade contractors being brought into these lawsuits. We got to fix the indemnity problem. The focus was on how do we share the responsibility for these claims. It's a complex area of the law, not enough time to get into it today, but as Senator Fan mentioned, here's the good news. The good news is during the last 4 or 5 months, the principals for the subcontractors and the general contractors have sat down and they've worked hard towards a solution. I'm here today to suggest that I'm optimistic that's going to happen. I'm optimistic there's going to be a proportional liability solution that can be worked out. I'll leave it to some other speakers who I know want to go into some of the details. But let me just identify a few challenges we're going to have. There's 2 aspects of this. First, you have to have the duty to defend claims. So an indemnity has both a duty to defend and then a question about who pays at the end if there's a real defect. So we've got to deal with the duty to defend. As I mentioned, homes aren't perfect, but these CD lawsuits, I submit, are overblown. Why are they overblown? Because the more parties you get into the case, the more defects you have in the case, the bigger the case looks, the more incentive there is for the insurance companies to settle. So the whole mechanism is set up to blow the claims beyond the legitimate ones in order to get a big number, in order to get a settlement. So we have to do something about that. We have to create some incentives, not the incentive to settle, but the incentive to defend against meritless claims and to resolve other claims. So here's the question. One of the real challenges is when we start talking about proportionality in the indemnity sense, how do we decide what is the trade contractor, the plumber or the roofers, what's their fair share, what's their proportionate share of a claim that doesn't have any merit? It's very difficult to try to get your mind wrapped around that. What ought to happen is there ought to be a locking of arms between the trade contractor and the builder to defend against the bad ones, to defend against those claims that don't have merit. At the end of the day, if there is merit to the claim, then I think we have to have a system, and we've talked about that at the end of the day, if there's merit to it, then the liability ought to be proportioned to the responsible person who either did some defective work or caused the problem. There's no problem there. But it's a challenge because you have two different concepts. Duty to defend against the frivolous claims, the meritless claims, and then a proportional liability for those that do have some merit. The goals of the legislature since 2002 to the present have been very consistent. They are to take care of the homeowner, and the homeowner wants their problems fixed without litigation. That's what they want. They don't want to be dragged through years of litigation. They just want their homes fixed before a lawsuit is filed. For the trade contractors, they want the right to go in and fix the problem, and they want the right to defend their work if someone is attacking it without merit. And the home builder wants to deliver a good quality product, wants to have a good relationship with their trade contractors, wants happy customers who'll come back and buy another house. The legislature in every iteration from 2002 to 2006, 8, and 15 always had the same goal. Get a system that gets things solved before litigation. All three parties I've heard say we'd like to get problems before litigation. So we have to tinker with that side of the equation. But the last thing that I want to mention, though, is if we come up with a system, and I think we can, to fairly allocate responsibility for real defects, if we can come up with a system that gets things done before the lawsuits are filed, I think we can do that. That's appropriate. But we can't ignore number 5 and 6 on your study. We need to have a system, not like the one we have today, which perversely encourages overblown lawsuits, as Senator Fan mentioned, for all the reasons that it creates this whole machine that drives all this construction defect litigation. We got to do something to address the frequency and the size of these construction defect lawsuits and get them down to something that are real defects. Instead, we need a system that encourages fixing problems and provides a mechanism that can really work. So I'm confident that we can solve the problem of proportionality between the subs and the general contractors, but we have to create a system that has disincentives for recruiting people to sue on a multiplicity of claims, bring as many parties and insurance companies into this lawsuit in order to kind of leverage a settlement. So yes, let's have a system that better divides up the pie if there is some responsibility. But we're not solving the problem if we don't solve the problem of the frequency of the lawsuits, the size of the lawsuits, because, you know, it's one thing to fairly divide up a pie, but if we're adding more and more and more pies and bigger pies, then we're still going to have the same problem. We're still going to have subcontractors writing $5,000 checks over and over and over again. So I'm encouraged about our ability to solve the proportionality indemnity issue, but I hope that we can also focus on 5 and 6 and figure out a way to get rid of these lawsuits. Not that there aren't some meritorious claims, there are, but to bring it back to just the meritorious claims. And I'll leave it to others to address some of the specifics, but I'm glad to answer any questions.
Thank you. That was wonderful. Thank you. Questions of Mr. O'Malley, members? No? I have one question, please, Kevin. Where does the ROC fit into this process, or where are they not fitting into the process? Because, you know, generally, if there's a complaint, it used to be anyway, instead of running to attorney, if there was, you know, you contact the contractor or subcontractor, say, I have this problem, and if it's not resolved immediately, the next step was you go to the Register of Contractors, because that's why our contractors are licensed and bonded, and we have this whole system set up at the ROC to handle these kind of things. How is it we've gotten away from that process where we're running to attorneys now for lawsuits? Can you help me understand that, please?
Sure. I think it's always been kind of a two-track system in that sense. You're exactly right. Hopefully what the homeowner does is call the warranty department at Pulte or Shea or someone, and they come out and fix the problem. But if that didn't happen, you're right. Then you could file a very simple, you didn't need lawyers, file a very simple form, send it to the ROC, and the hammer the ROC has, they will go out and do an inspection. They'll then tell the contractor or subcontractor, this is a problem and you need to fix this. If they don't fix it, it's under threat of a sanction, including losing your license. And so that's the hammer on the ROC side. And it's a good system for what it has, for what it can resolve. But I would respectfully suggest to you, the reason that there's a disconnect, Senator, is that it's not in the interest of the lawyers filing these lawsuits to have the problem solved through the ROC. They're kind of what the California people told us was the cottage industry, so to speak, of these cases. They need to get it into a litigation setting. They need to get as many claims and make the problems as big as possible. If you run it by an inspector over at the ROC, they're not going to buy on 50 alleged defects. They may buy on 1 or 2 that needs to be fixed, but they're not going to buy it. So it doesn't fit their kind of mechanism of how they want to, as you say, make a little extra money.
So to that point, and I'm just throwing out an idea for discussion when you guys meet again individually between yourselves, is that something we should be looking at? Should we strengthen the way our laws are or the procedures that maybe they need to go through the ROC first before getting an attorney involved or something? I'm just throwing an idea out there that maybe our current system isn't set up strong enough to be able to handle some of this stuff that should be handled on the lowest level.
And there's no doubt, Chairman, there's no doubt that any mechanism we can get to that is simple, straightforward, and gets the homeowner's problem fixed quickest without litigation involved, I'm 100% behind. So I think it's an avenue worth looking at. I do recall someone at one of these hearings a year or 2 ago saying, kind of, we need a little more funding for the ROC. They don't have enough inspectors and that kind of thing. So there may be a challenge there in terms of their ability to take this on. But anything, Senator, that gets us down that path of an early fix without litigation, 100% behind.
Awesome. Thank you. Senator Contreras?
Madam Chair, Mr. O'Malley, and I'm sorry about my voice. I think Diego took that from me on Saturday. But the one thing I wanted to just touch on, since you just mentioned that, is that I think the speediness of the process of when it starts and how the consumer is able to make that quick call and get a quick response is probably the cause of where we're at today. So many consumers out there. I mean, in my district in the West Valley, that's where the houses were built. That's where the problems were coming from where not the central area, from engulfing our areas in the rural areas that used to be just farming towns. So a lot of times, these are individuals that don't have a lot of money. They don't have a lot of this and have a lot of that, but they bought their first home. So now they go over there and they're trying to make calls because they do have some defects because they were blowing up houses really quick at one time. And the consumer was the one that was left in the background because they were the ones with the least amount of cash. So all of a sudden now here we are with this problem today. And now the people with all the money are having a problem because of all these lawsuits. So I wish we could streamline. I wish we could figure out how long does it take if a regular consumer calls because they do have a complaint about their home or something that's happening in their home. I would really love to know what that timeline is from the time they make the call to the time they get a call back and to when somebody is taking action to what's going on in their home or their dwelling. So that way this could calm the rest of this down. But I don't think anyone's ever spoken to that about how quick the response is until today. I mean, and we had this committee to where we were here all night talking about it, but it was never. I want to go back a bit and take a few steps back, and let's start there. Let's start there with the consumers, and let's see where we can improve in that one call, and maybe we could cut the attorneys out. But I mean, that's something that was brought up right now.
Co-Chairman Senator Contreras, I think you're exactly right, and what I'd like to do, with your permission, is get you some statistics that will assist you in analyzing that issue, because we gathered some of that last year on how many warranty claims or customer service claims came into some of our large builders. And you're right, a lot of the homes are being built in the outlying areas. One of my cases was out in Avondale, so I understand what you're talking about. But we gathered some information about how many calls came in, how many were responded to, and how long it took. And my memory of that, and I'll get you the statistics from one of our builders, was about 90% of them were resolved just by the call to the customer service group, and I think the average was about 10 days from call to problem solved. But I'm glad to get you those statistics, and that is obviously the first step, for sure.
Yes.
I had a question regarding, is there a statute of limitations on reporting a defect on a home?
Co-Chairman Representative Espinoza, yes. It's a little bit of a complex area because we both have a statute of limitations that applies, but the most important time limit is the one that governs what are called the implied warranty claims, and that is called the statute of repose. And that says if you have a defect in your home, you have to file a lawsuit over it. You have to get the process going within 8 years after the home has been built, or if it's a latent defect, you get 1 more year. So 9 years is the outside limit for filing claims about a new home.
Thank you. Thank you, Madam Chair.
Thank you. Any other questions? Thank you. That was great. I appreciate that a lot. Next, we'll go with Angela Cooner with the Subcontract Association. That's going to give us an overview of construction defect litigation from the subcontractor's perspective and where we might look for improvements. Morning. How are you?
Good morning,
Great.
Madam Chair, Mr. Chair, and members. My name is Angie Cooner. I am here on behalf of the Arizona Subcontractors Association, or the American Subcontractors Association of Arizona, and Arizona's for Fair Contracting. And we could talk. I think I'm the only one in the room, maybe Mr. O'Malley, who gets really excited about defense, indemnification, and allocation of fault. And I realize that you don't. So, why does this matter? Why is this an issue? Why is it an issue that's not just a blip on the radar? And it really goes to what Senator Contreras raised. Our governor has hashtag Arizona on the rise, right? Population growing. Economic development is one of his priorities. We take pride in Arizona in our local businesses and encouraging our entrepreneurs to come here. So what's happened? People have come. And we're growing and we're growing, and the construction is moving, and it's not just the residential, but it's also the commercial, the infrastructure. All sorts of building is going on. Because of all of the building, we've set the stage for, I don't mean a little bit of construction defect litigation. I mean, think about how many people have come and how many homes have had to be built. We're talking a massive amount of money is involved with these construction defect litigations. It is not uncommon for there to be 25 to 30 defendants in one lawsuit. That means that many subcontractors, insurance carriers. So when we're talking about there being a cottage industry that has been blossomed up behind our very positive economic development, we need to make sure that we don't have the pitfalls that can come alongside that, which are increase and unaffordability of home prices. We want our residents to be able to afford to own their own home. But if we continue with these exponential increases on litigation, insurance, and all of these other expenses that are associated with construction, we're going to end up like California too, in that we're not going to have affordable homes. We're not going to have the ability to get the person that wants to come in and open the mom and pop store and buy their first home. We won't have that capacity if we don't take some affirmative steps right now. So there's just a lot of money at stake. And when there's a lot of money at stake, abuses can happen, right? The person that's in the most power or the people that have the most ingenious ideas can often take advantage of those situations. So what we wanted to do is, these are the 6 topics that we're going to think about and work with our builders and work with our homeowners and our realtors and figure out how to resolve these issues. But I wanted you to understand, what are the driving forces behind it? Now, the one issue that we stand arm in arm with all of the home builders, and I say we being the subcontractors and the homeowners together, is we have a massive labor shortage. We have a massive labor shortage. We have everyone in their mind at high school is, I've got to go to college, right? I'm not, and of course then we'll all be sitting in a field coding our tablets. We won't know how to build a house. We've got to get tradespeople. To get tradespeople, we have to set them up for success, right? We have to make sure that when they go to open that mom and pop plumbing company, that they aren't immediately obliterated because they can't get insurance or the CD litigation crushes the little guy out. We have to pay attention to our labor shortage. How we get there, of course, the devil's in the details. But the premise, we are all arm in arm. The major developers, the major home builders, the small home builders, they don't have enough workers. So how do we, this is a real issue that as a state of Arizona, we want to make sure that we have an inviting situation for our entrepreneurs and our new businesses. So we want to address the labor shortage, and that's one of the big issues that we talk about in these meetings with the home builders and with the realtors. We also want to work on the insurance costs. So many of the constituents that I work with, there's really only 2 insurance companies in the state of Arizona that will write them policies. Do you think those policies are fairly priced? No. They are extraordinarily overpriced. Many of them have hundreds of thousands of dollars in deductibles. They're called SIRs, but they're in essence deductibles. They have to pay $50,000 for every lawsuit up front, or $100,000 just to trigger the insurance. Because the way that our system is set up is we have a lot of building. We necessarily then have lots of CD litigation, and then it trickles downstream. So we have to work together to make sure that our Arizona environment, the building doesn't outweigh the labor available, and the building doesn't outweigh the cost. So we need to bring some of these things back up to an even playing field. It's important for us to remember as well that the homeowners do need these repairs. And so to you, Madam Chair, you had asked, what's the disconnect? And I agree with Mr. O'Malley, but I also want to point out a couple of things and maybe take it one step further. I think it would be interesting to know, and I don't know that we can track this, but I think it would be interesting to know how many of these homeowners contact Pulte or D.R. Horton or any other home builder and say, hey, I've got a problem, and they come fix it. And then the registrar contractor window of time is 2 years. So now the home was built in, say, 2010, and now it's 2012. You go down the path, and now we're at 2016. And you've got an attorney knocking on the door going, hey, will you guys fill out this sheet? Do you have caulk peeling or your toilets running? And you just go through and you run through the entire house. And then the homeowner is sold on bringing a lawsuit again, even though they may have had the warranty issues. Is that always the case? Absolutely not. There are very legitimate CD cases out there. But what we're speaking about right now are some of these where a lot of money's at stake, and these plaintiffs' attorneys are trying to get their fair share, or more than their fair share. So we have to keep in mind that there is a disconnect between the easier process of the registrar of contractors and then the 8-year time frame where you can file a lawsuit. It's also set up right now where the attorneys, and Mr. O'Malley spoke on this, and we agree 100%, there is no incentive to get the repairs done from the plaintiff attorney side. It's very difficult to get a third, a contingency fee. If I want a third of a $100,000 judgment, I get $33,000. Well, how about a third of the plumbing repair and the repainting and the roofing? Well, that doesn't incentivize them to want that because that doesn't put money in their pocket. So there's this concept behind and this kind of tug of war behind the idea that we want the homeowners to get the repairs, but the homeowners' attorneys who are representing their interests, they want to get the money, and then you can pay for the repairs after you pay me. It's created a situation where we just need to put some safeguards in place. We need to re-incentivize the homeowners and give them an avenue that's quick, that's easy, and that fixes their issues. We need to coordinate that, I think, with the registrar of contractors so that we don't have 2 sets. How many homeowners went through the registrar of contractors and then went through a lawsuit later? I'm sure it happens. I just don't know. That's what I mean by I don't know if there's information on that, but it would be curious. I would be curious to see. The most important thing to my subcontractors are the insurance, and they're not involved with the repairs. We're not involved, and we don't get the opportunity to go make these repairs. So we don't get the opportunity to help avoid the litigation. And then, as Mr. O'Malley said as well, when those lawsuits push through, it is just passed down. The number is passed down to the sub. They are the small companies. They are the small contractors. They are many times mom and pop shops. And they're the ones that are ending up with the rest of the bill. And so we do have to address some of these things. It is just a nature, and it's a growing pain, I think. They don't have this problem in states where the development isn't quite so much. But we do need to address it, and we need to make sure that it doesn't become off balance.
Thank you. Questions? Yes.
Thank you. Thank you for the presentation. Could you give me an example of another state that has any type of system in place of reporting that allows the homeowners to have immediate repairs and any other type of anecdotal remedies that have been offered through any type of state program or other sources?
Co-chairs and Representative Espinoza, are you asking, and just because I'm having trouble hearing you, are you saying that you're asking about whether there's statutory programs in place, or are you talking?
In other states?
Yes, there are. Texas, Oklahoma, Utah, Colorado, California has one, but it's obscure and difficult to follow. But there are those processes in place. What's different in, say, Oklahoma, Texas, I'm from Oklahoma, and so the homes that we have, we just don't have a whole lot of new homes. So you don't have the entire community that just got laid down with 200 homes. And so the laws are different there, and it's easier to use there because when you do have a construction defect situation, it's usually just one, maybe two homes at issue. It's not an entire community. But California, Florida, those are the two construction defect states that are just, they went through a similar growth as we did. And so they're having to deal with that. New Mexico is starting to go through the growth process, and the building's moving to there. And of course, Nevada had it just before us.
Thank you.
Thank you.
Any further questions? When you are meeting, obviously this is, as we balance these lines between developers and generals and subs and everybody else, we also, I'm hoping in your conversations that you all are having, that we're also making sure that we balance and protect our home owners, that if there is a true defect, then how do we get that, as Senator Contreras said, how do we get that resolved as quickly as possibly without undue burden or expense on the homeowners for something that it should have been fixed? So am I correct in assuming that those conversations are part of the bigger picture that we're talking about in your meetings, or not?
Co-chairs, it is without a doubt one of the biggest points. You've raised the biggest hurdle for us, which is we have the Registrar of Contractors and warranties. You move into a home, you have warranty for a certain period of time. Well, the warranty is shorter, and the Registrar of Contract period is much shorter than the litigation. And so once we get, most of the lawsuits that we see are in that 8th and 9th year. That's just the way that they are. So by this point in time, the question is, well, is that a homeowner maintenance issue, or is that a real defect? And if it was, did you call the warranty company? And so the legitimate and the strong construction defect cases we're seeing closer to when the home was built.
But to that point, Madam Chair, yes, you're going to find some of these problems at a later date, not at that initial. I mean, if it was more, that's why when you buy a home and you only have that home warranty is only that 2 year thing, because they don't want to keep going out for the other stuff. But when you're looking at the structure, and you're looking at the foundation, the walls, the stucco, all that stuff, it's usually not at that beginning stage. It's at that further stage when the house is now settling, and now who gets stuck with that? Because as you mentioned, the ROC only oversees this for the first 2 years. For the first 2 years, the actual homeowner only has the extended warranty on that home. So all of a sudden now, at that third year, at the start of that third year, now you have homeowners that bought that dream house to put their little Johnny or whatever inside a home to start their family and to do their thing. Now they're into that problem stage to where it could cause a lot of problems. Because it's not just that, oh, you know what, that switch or that something's going on. It's something bigger. So I think, again, that's one of the things that I think we've spoken about the least is, again, the consumer. the people out here in our great state that I've lived my whole life, that I've seen these houses come in like crazy, that we need to go back and we need to start getting quality workers, doing quality workmanship for the quality people that we have in Arizona. And I think that's where we need to go back to. And I think sometimes we get lost up here, and we've been battling this because all sides are going at each other. And one thing I've said to everyone that has spoken to me, we need to do something and put the consumer first. And I think that's where we've gotten lost. So that's one thing, again, I said it when we met in committee, and I'll say it again. I hope that we have come to somewhat of an agreement. I've heard that we have, not all total, but there. But let's put that consumer first.
Thank you. Any other questions? Great. Thank you very much. Appreciate that. Okay, next, I believe Ryan DeMena was going to come up and for 2 minutes. And you were going to give us kind of an update on the process of what we've been doing these last few months to get us this ball rolling. Can you address that?
Absolutely. Thank you, Madam Co-Chair. Madam Co-Chair, Mr. Co-Chair, and members, for the record, Ryan DeMena with DeMena Public Affairs here on behalf of Arizonans for Fair Contracting. Little side note, DeMena Public Affairs recently voted Best Family Business. Just thought I would add that. Want to
My
throw out...
understanding is that was completely rigged. That was not a legitimate news source. Fake news.
Wasn't
is what I
hairdos,
heard.
was it?
Fake
Mr.
news.
Co-Chair, let's not go too far down that path. Would also like to extend my congratulations to Mr. Co-Chair as well as to Mr. Hanna. So. Grant did an excellent job in providing the overview, and also want to compliment the presenters, Mr. O'Malley and Angela Cooner as well. I agree with Mr. O'Malley. I am optimistic about the conversations that are currently underway and that a solution is on the horizon, and would like to especially thank Angela for her efforts, just time and hours that she has put into this. She is volunteering on this exercise, and it requires a great deal of her time. So I also want to thank each of the members for taking the time to serve on this committee, and Senator Fan for championing this issue. Thank you. So I'm here to provide an overview and an update as to where we are in this process. I will keep my comments brief, but I also think it's important to provide just a little context. So Arizonans for Fair Contracting is a grassroots organization that was formed in the fall of 2016. The group serves as a united voice for the contracting community at the legislature. This group's focus is to put an end to the unfair risk-shifting practices you've been hearing about in private projects by working to ensure that each party bears the cost of its own negligence and in proportion to each party's negligence or proportional liability. These subcontractors want to be held responsible for what they do, nothing more and nothing less. The concept already exists in public projects, which has been touched upon, where liability is proportional to negligence and each party pays their respective share of any loss. So this issue has existed at the Capitol for quite some time. It predates my time at the Capitol, and I have actually seen minutes from hearings in which a young John Mangum is discussing the problems with what he calls cram-down provisions. So with that in mind, though, I'm confident that we are experiencing a moment in Arizona contracting, and I believe that this study committee is the vehicle to identify the legislative solutions necessary to tackle some of the issues impacting Arizona contractors and level the playing field in Arizona construction contracting. The CLASC, again, as mentioned, was created under Senate Bill 1271, sponsored by Senator Fan. But the introduced version of the bill included a legislative intent clause, and I'd like to share part of that intent clause because it accurately reflects the objectives behind proportional liability, and I think it touches on each of these key points and how they feed into the final point. Quote, "Is the intent of the legislature to extend the provisions governing proportional liability in public contracting to private contracting. This will ensure fairness in construction contracting between general contractors and subcontractors, and will create an economic climate that promotes safety in construction, fosters the availability and affordability of insurance, and reduces the legal costs associated with construction claims." So having said all that, where are we now? Since the legislative session has ended, the Arizonans for Fair Contracting Group has formed the Technical Advisory Committee, or the TAC. The TAC, which is led by Angela, is comprised of some of the brightest attorneys and insurance experts in this area, and they have been reviewing statutes in other states in search of best practices and possible solutions to these issues. This group is developing what I refer to as the menu of options. Again, just want to thank Angie for her time and devotion to that process. On a separate track, the Arizonans for Fair Contracting's ongoing messaging has started a dialogue in Arizona's contracting community. And I'm pleased to share with the study committee that there have been a handful of encouraging peer-to-peer discussions between the builders and subcontractors. It quickly became clear to me when I was able to sit in on one of these discussions that there's a lot more this group can agree on than not. This group is lovingly referred to as the Enchiladas Working Group, as Enchiladas has emerged as the go-to location for these discussions.
Wow, thanks for the invite.
Cheese crisps on me next time. So as a result of the Enchiladas Working Group discussions, we've started a dialogue with attorneys for the builders and are working to further develop this menu of options. We will shortly be ready to discuss specific concepts, but I think it's safe to say that there are two overarching goals. One, pre-litigation, and again, you've heard this. We need to find ways to work together to limit construction defect lawsuits and help homeowners get the repairs that they need. And on the back end, in the case of litigation, we need to identify a system that proportionately allocates liability between contractors and subcontractors. Moving forward, I would hope to have a larger stakeholder dialogue to further flesh out the menu of options and eventually identify the concepts that everyone can support moving forward. I think it's important that each of these concepts identified are able to call what I've been referring to as the political tolerance test, which is effectively the final filter in the process. In the end, the goal is to develop a consensus product that everyone can support in the rapidly approaching 2019 session. So having said all that, I'll close with this. It's time to put pen to paper, as there's a deadline that no one in this room can escape. I checked this morning, and there are only 96 days until the start of the 54th legislature first regular session. And when you account for Thanksgiving and Christmas, it is right around the corner. With that, I'm happy to answer any questions or turn the mic over to Mr. Camps.
Thank you. Any questions of Ryan or where we're at with the working group? No?
Thank you.
Okay, thank you. Pardon?
The working group's not hungry.
Obviously not. Obviously not. Mr. Kemps, I am bringing him up here, and if there's anything he would like to add that he feels that we have missed or anything else. So it's up to you. If you have something to say, fine. If not, that's all right. Loopy's laughing.
Something to say.
I think that was a subtle invitation to sit down.
No. Whatever. I didn't want you to feel compelled to say something if you didn't have anything to say.
Madam Chair, Mr. Co-Chair, Spencer Camps with the Home Builders Association of Central Arizona. I will be brief. There's not a whole lot I will add. I think Kevin and Angie and Ryan all did a good job explaining some of the issues and characterizing the events. But I did want to touch on a couple issues that I think is important. You know, first of all, I want to thank you for the study committee, Senator Fan, the work you did on this issue last year, although, you know, I don't know if I characterize it as fun, but it brought us here today, and that's a positive thing. I'm grateful to the committee members for the time and focus on this important issue. I've been working on this issue literally for, I think, over 15 years, both construction defect litigation and indemnity. It has been highly contentious. That is literally an understatement. And the reason is because, in my opinion, it probably took me 15 years to figure this out, but it's very personal, okay? You heard a lot of description about these mass action lawsuits that all have some frivolous nature of them that are essentially questioning the work of a builder or trade. And when you question the work of a builder or trade, you're questioning the company. You're questioning the publicly traded companies that I represent down to the custom builder. You're questioning the trades and their company. Most of these individuals have their name on the company. You're questioning the mission of who we are and what we do. You're questioning the employees we hire and train. And when you do that in an unfounded manner, that creates a very personal situation, which brought us to last year. Last year, it's why the trades chose to introduce 1271. It's why we chose our angle approach on this issue. But the goal of both sides, I think, fundamentally, is the same. We want to be able to defend our work. We don't want our work questioned with ridiculous lawsuits. And we want to go do what we do best, whether that's plumbing, whether that's framing, or whether that's building homes. We want to go do that, and we want to do it well. And so we're seeking a solution to the problem of individuals that we think frivolously question that work and therefore question who we are. And so that's kind of the nature of the issue. But the good news is that out of discussions last year, obviously my board directed me personally to engage in conversations with the trades. Ryan characterized it, I think, as well, very well, even with the enchiladas group that we've thrown into this mix. But the legal team is working diligently, I think, to try and put pen to paper. But the fundamentals are there. The fundamental agreements are there. The conceptual agreements are there as it relates to let's fix our problems. If mistakes are made, let's quickly fix them. Let's make sure the homeowner is taken care of as quick as possible. If the lawyers need to fight it out, let that happen. But at the end of the day, to Senator Contreras' comments, let's make sure these homeowners are taken care of in an expedited fashion as quick as possible. And then let's do something about the frivolous nature of these mass action lawsuits. It was talked about the states that this was kind of happening in. It's the high-growth states. It's the high-growth states where there's been a lot of housing. It's Florida, Texas, Nevada, Colorado, Utah. New Mexico is new. It's really starting to pop there, and California is in that mix. And it is because those are the states, and we build differently in the western U.S. and in Florida, and we do large subdivisions. And when you can gather together 200, 300, 400 clients, that's the formula, and that's what they're looking for. To the individual claim, Senator Contreras, if that's all we dealt with, I'd be happy as a lark. I mean, that's why we have warranty plans. It's why we respond promptly to service calls, because next time you buy your home, we want you to use the builder again. That's how we get our best customer base. Not by marketing, by taking care of the individual who chose to take the step to make an investment with that builder and build that home. But we're not talking about individuals here. We're talking about an organized operation of mass action lawsuits that have spread across the western U.S. This is not a problem unique to Arizona. It's happened in all those states mentioned. It's a national issue. Our national association, the Rock Products Association, others have worked on this issue from a national level for many years. Having said that, I want you to understand it's complicated, okay? I don't want to walk away from this podium and not mention that. You know, I've tried to think for the last couple of weeks is how can I characterize that to this committee? This is how complicated it is when there is a frivolous claim filed. And Kevin talked about how these lawsuits happen. There is no contract between the homeowner and the subcontractor. It's only between the builder and the subcontractor. We take the lawsuit. Then we use the indemnity clause to bring in the sub if their work has been in question. If we believe that there's not a single legitimate claim in that lawsuit, not one, we believe that, we're obligated to still bring in the subcontractor and the trade, even though their work has been alleged to be in question. Alleged. And that's a very important thing. How do we, the builder, determine the proportional degree of fault of a subcontractor or a trade that's been involved in the construction of that home when we don't even believe it? That's how complicated this issue is. We think they're innocent. We believe they're innocent. We think the claim is without merit. But under the confines of the discussion we've had today, we've got to go defend that case and potentially settle that case and then figure out the fault of all the parties involved. That's not easy. That is not an easy thing to do. And that process, for good or bad, has brought us where we're here today. So I want to end up on a positive note because I don't want to be doom and gloomy. I think the fundamental agreements on this working group are there. I think the interests are aligned to come forward with a solution. The devil's in the details. We all know that. We've got to put pen to paper, as Ryan said, and we're doing that now. And so I hope the next time we have a meeting, I really sincerely do, I think we'll have a product, at least that may not be 100% complete, but I think it's going to be a really good start. So, any questions?
Any questions, Spencer? No? Thank you. That was very helpful. Appreciate that a lot. Okay, members, next thing on our agenda is committee discussion. So I would like to open this up to the committee members. You've heard, what the law is, what the problems are to some degree. Obviously, as been mentioned, this stuff has been going on for 15 or 20 years. So it is a delicate process, and it is, as I say, we just need to keep moving the football down the field to get to resolutions. I'm not expecting a Hail Mary touchdown by any means because of the complexity. But we as elected officials, we are in that unique and difficult position is that we are there to protect our constituents who are the homeowners, but we are also there to protect our constituents who are these business owners. I know, Senator Contreras, when we were dealing with this, you had a lot of phone calls from your local contractors concerned about what we were doing, how we were doing it, and how it would affect them or not. So all this stuff is taking all of that in consideration of how we are fair with this. So members, is there any information, questions, or anything else that we can ask of the working group to work on or get us information for? I'll go down the line and give me your thoughts where you're at after this first meeting and what questions you may have or what direction you may want to see this. And I'll start with you, Diego?
Thank you, Madam Chair.
Not you.
I want to thank everyone for the opportunity to present to us. I think was very informative. I have quite a bit of notes. Some of the things that really stood out to me is that with the amount of growth that our state has seen in the past is how, as legislators, are we encouraging to ensure that the workforce is prepared to build quality. And that's something that really sticks out in my mind, and I know everyone has a different avenue of how to approach that. But if we want to build quality, we need to start looking at that and how we can support the trades within the industry, ensuring that they are building quality, because I think a lot of that could be circumvented with that quality in mind of educating a great workforce. I'm also curious to see what other states are doing and what best practices they have and how we can incorporate that with our own individuals here and the professionals that perhaps even see a better way of doing things, ensuring that, A, we are taking care of the consumer at the end result, because as Senator Contreras mentioned, in my district, there are individuals that struggle just to buy a first home and to have experiences or challenges within that regarding that first home. They may not have the resources available. And I think also, too, looking at that, how does that impact them in their lives? And that's a concern for me as well. So I'm very grateful that the group is meeting at Enchiladas and working towards some solutions. But I'm also looking to hear about other solutions that may be viable options and bring that forward and looking forward to hearing from those. So with that, I'll close.
Great, thank you. I think I'll go to Lupe. And then Senator Contreras.
So wanted to hear the House all first. Well, again, thanks for everyone coming out today, and being short, so I can go back to work. But no, there, as I've said already, my main objective for this whole thing goes back to the people that have entrusted us to be here and make some decisions that are not going to be easy, some decisions that are not going to be very accepted by some people in this same room. But that's the job that has been given to each and every one of us. You guys get hired, we get elected. You get hired to do a job, we get elected to do a job. Okay? The money we make is a whole lot less than what you guys make. but that's okay. That comes along with what we do, and that comes along with what the people in our districts, and as Senator Fan mentioned, not only the individuals that are buying the homes, but the individuals that are doing the work, the craftsmanship. A lot of them live in my dad was a construction worker his whole life. Every year of my first 40, 30 some odd years of my life, my dad was out there working construction. I know the hard work that those individuals do, and I know the passion they put behind the work that they do. I also know how they can be pushed to get that job done quick, to go on to that next home. The more houses made, the more money made by that company. Not so much by that worker busting his butt, because he gets paid by the hour. It's by the owners of those companies, by those contractors. But at the end, who's the person inside that home? It's that family wanting to have maybe that first home, or maybe they already bought their first home, but this is their first new home. So we need to get back on track. We need to really work with one another and put that out in the beginning, and really talk about how we protect them. We hear a lot. We've heard a lot last year, and even today, about the frivolous lawsuits. Well, yes, there's a lot of frivolous lawsuits and a lot of things out here. I'm in the Jude committee, and I hear that all the time. But the attorneys, we're never going to get rid of attorneys that want to try everything out there just to make an extra buck. We're not going to get rid of them. Yes, we need to figure out a way how to limit what they're able to do and what they're able to bring to the forefront. And I think it's easier said than done on your guys' side and our side. It's just trying to find that common ground. And I hope this off session has got us closer to that common ground. And again, as I mentioned earlier, I do believe we're closer than ever, because I don't want for what we went through last year to happen again. Okay, we will be back, and we will be fighting the fight. Like it or not, we will be fighting that fight. And I just hope that we're able to come to that end conclusion of, hey, look it. We're shaking hands, we're walking away. We didn't get everything we wanted, but we're a step closer to that finished product, but we'll end it right now. And we'll see what's going on. So hopefully we can get there. And again, one last thing, please put those consumers on the top of that list. Put them there. Respect the people that are buying your homes as we respect the people that are putting us in this position. Okay, so if I could leave you with one thing, please do that and bring us something that we can all work with. Thank you very much.
Thank you, Senator. Speaker Pro Tem Shope and
Thank you.
co-chair. Thank you for being my co-chair.
Yeah, you bet, Madam Co-Chair. First off, I want to thank everybody for being here today. I think there was some good discussion. I've had the opportunity to meet with, I think, pretty much all sides of this issue over the last month or so that we've been leading up to this. I think the pronunciation is CLASC Committee here. Or at least that's what was said to me in an email. So I want to thank you all for reaching out and such. One of the things I think it's hard for me not to go ahead and say, look, I know that the issue is difficult. I had a portion of it, obviously, in the House last year along the periphery. And I think this is good where we are right now, that we're actually speaking to each other, we're actually hearing from each other and sitting down as a working group and as a committee as well. And I guess that I would don't want to belabor the issue too much with the over details, but my general feeling on this, as well as other difficult issues that we deal with, is not to let perfect be the enemy of good. If we can end up someplace better than we are today, then I think that's a positive change. And I know that oftentimes, and trust me, I know it in every other issue that we deal with here, and that is that sometimes we'll go ahead and not agree with something because it isn't 100% of what we want. And frankly, I graduated from college with a 2.5, and that's 75%, and that's pretty darn good to get a degree at most institutions, thankfully. And I got the same piece of paper that everybody else that graduated from ASU got. And of course, all it got me was a $24,000 a year job. But the reality is, folks, let's remember. I think what everybody's doing here is good. What everybody's working towards is good. And if we can end up with something that's good, and maybe admittedly is not perfect to everybody, I think we're going to end up in great shape compared to where we are today. So I would offer that sense of encouragement to everybody that's working on this today. Thank you.
Thank you. Good comments, everybody. That's awesome. I wish that Jill and Rick were here to add, but we'll bring them up to speed on this stuff and let him figure it out too. Many of you know I am a contractor myself. I'm a licensed contractor. The difference is that I have a highway construction company. So I bill horizontal as opposed to vertical. However, past president of the Contractor Association up in the Yavapai County area, I have worked very closely with builders. So we have seen, particularly when the boom was 10 years ago, right? A lot of out-of-state contractors did come in and were throwing houses up. You are absolutely correct, Senator Contreras. And when all of a sudden the boom hit, they packed up their bags and took off back to their other states and left many of our existing contractors that are in the recovery fund, as well as the homeowners and everybody else, confidentially or quite honestly, is we were left holding the bag. So we do know that there is some not so great people out there. And we need to figure out a way to fix that and keep that to a minimum, especially in these tides of up and down. On the flip side, I can tell you from personal experience, I have seen lawsuits and complaints from homeowners where I'll give you a couple examples. A lady sued a contractor because it was actually ended up being the subcontractor who did the cabinets, because she would pull the bottom drawer out and step on it and use it as a stepping stool to reach the upper cabinets. Now we know that drawers were not meant to handle 150, 175 pounds, right? They're just not designed that way. I had somebody, a complaint that was interesting, that brand new house built, they were doing the final, and it had been a couple of weeks, and the homeowner said, oh, look, there's black specks up there. This was in rural Arizona. There's black specks up there on the white eaves, and when the inspector went up to look at it, it was literally fly droppings. And that homeowner demanded that the house be repainted because that in that couple of weeks from the time the painter had finished painting to the other, that there were fly droppings. So you can see it can get pretty crazy and silly on both sides, and that's what this group is trying very, very hard to accomplish, is to protect those that need to be protected and to make sure that our subcontractors and generals and developers don't get pulled into this stuff. Because as Angie said, one of our also ultimate goal is making sure that we have affordable housing, making sure that we don't allow litigation and everything go so sky high that all of the builders in the room are having to add so much into the price of their homes strictly for litigation and lawsuits, because that certainly isn't helping those of our constituents that want to buy that first home. So important. So that's all I had to say. Now let me go to Grant or Ryan, either one of you. The next thing is our future meeting date, and that would tie in also to where the working group is, where we think we're going to be in what period of time to come back and meet with all of us to bring us back up to speed with any information we need or where you're at. Ryan and Grant, I need your help with that. One of you, both of you.
Madam Co-Chair, Mr. Co-Chair, members, in terms of a next committee meeting date with respect to where we are in the working groups, we have identified a deadline we're about 2 weeks out to get together again. And in that meantime, we will have truly put pen to paper on some of the concepts that have been identified. So again, being respectful of your extremely busy schedules, the thought right now would be potentially another meeting at some point in November to discuss sort of where we are in this process, and then a meeting in early December, which would allow us, I believe, to conclude the study committee meetings and in time for the reporting deadline of December 15th.
Correct. Okay. Grant, did you want to add to that at all?
Madam Chair and Mr. Co-Chair and members, as far as our deadlines are concerned, December 15th is the date for the report and recommendations. I think the plan, Madam Chair, was today we outline kind of the problem and go through the committee charge, and then in the next meeting discuss some of the potential solutions or recommendations this committee may decide to take, and then have probably in mid-November, and then have a final meeting in December to review and confirm and officially take a committee stance on what that report will include.
Okay. It was suggested perhaps the first week of November might be a good time to have that meeting. Members of the committee, does that look like something that's doable with you guys? Obviously, we know Tuesday the 6th is election night. And I know we're all busy doing this. I will tell you, it's my understanding that the Senate will be having, I believe it's on Wednesday the 7th at 1 o'clock. We are scheduled to be here to vote on leadership, I believe, and the 8th for the Democrats. So you guys would be here on the 7th and 8th as well. Do you guys have a time for that?
Not as of yet.
Okay. And 10 a.m. on the 8th, right?
Yeah.
Okay, and ours is 1 p.m. on the 7th. Okay. Speaker Pro Tem Shope, do you know what the House's schedule is?
I don't know exactly, but traditionally we have done so on the Wednesday following Election Day at some point in the mid-morning or early afternoon. But I am open either the 7th or 8th to do that.
Okay.
To do this meeting.
Okay. So we have if we're going to be down here anyway and take time away from our jobs or responsibilities, I was trying to coordinate. So if we're doing, some of us are doing meetings at 1 o'clock in the afternoon, the 7th, we can certainly do like a 10 a.m. here on the 7th.
Madam Chair.
Oh, yes.
I don't mean to interrupt.
Please do.
I do have a directive from my director that we're trying to avoid meetings on the 7th and 8th.
And the 8th as well?
Yeah, that was
Okay.
prior to any discussions here. So I think, if possible, maybe that the following week.
Okay, thank you for letting me know that.
13th, 14th, or 15th of the next
14th would be great for me.
Okay. Unfortunately, that won't. No, it's fine. It's fine. No. It's no, we're good. That was another week. Never mind. I was thinking of rural transportation. So please let me know what works best for you guys. 13th, 14th, or 15th.
Right now, either one of those dates sound good to me, but
Okay.
it could be, that could change. This is my November, December, my travel months. So like the last 2 weeks, I'm traveling all over
Okay.
for business, and those two might get filled here pretty quick. And
My preference would go with the 14th,
Okay.
yeah, I was.
but I am open the 13th and 15th.
I'm available as well as the 13th and the 14th.
Okay, but not the 15th.
I am available on the 15th.
Okay. So, Grant, would you do me a favor then? I'm hoping this works for everybody out there in the audience as well. Could you shoot out an email or whatever to everybody and say, here are options, which works best for both, for most, and then that's what we'll do, right?
13th, 14th, or 15th.
Right, one of those 3 days, all right? Does that work for everybody? And then we'll check, obviously, with Senator Gray and Representative Norgard to make sure that they...
Do whatever we say.
That's exactly right. So with that, if there are any other questions, comments, thank you all very much for coming. Great meeting. Moving on down the road, and we are adjourned.